I just want to know specifically what you said, ma'am. I have to believe you're guilty of something. So tell me what you did.
There were multiple messages over a span of.
Great, I heard you. Now tell me what you said in the messages.
There's nothing specific. I just called her a bad person. I said that this.
You're a bad person. That's what you put on the text? Yes?
Yes.
So I won't see anything more than you're a bad person?
I mean, I went into the situation. I listed out the lies. I listed out.
Swear at her? Did you call her names?
I don't think I was name calling until the end.
Well, at the end, were you name calling?
I think I did call her.
What'd you call her?
I'm sorry, bitch, on my son's second birthday.
And you texted her how many times, say, within the week preceding that?
Oh, I don't think, it wasn't. It was the one time that I called her out of her name was my son's second birthday, but it wasn't like, I wasn't texting every day. It was just like.
Can you help? Feel like,
Sounded like everything like.
yes.
Ms. Henry, you said this solely dealt with text messages to this complaint, correct?
Yes.
It's under HIDA. Is that right, ma'am?
Yes.
And then we're gonna go ahead and dismiss the stalking. If you plead to that under HIDA, I'll set terms and conditions. If you're compliant by, when you come back, the case will be dismissed on motion prosecutor. And they're saying, you know, possible proof issues, justify reduction for, including HIDA. So, do you understand everything here? If you plead guilty, the possible penalties under this, for disturb the peace under HIDA are up to 500 fines, 90 days jail, costs or all those. And then I'll dismiss the stalk. You understand?
Yes.
Did you sign, read, and understand the advice of rights? If you plead guilty, you'll be giving up all those rights, and we're not going to have a hearing or a trial. Do you understand that? You got to keep your voice up.
Yes, sir.
All right. Is this how you wish to proceed? To the charge disturb the peace, how do you plead?
Yep.
On March 16 and 26 at 3:22 p.m., were you on Montebello near Albert and Woodhaven? You weren't on Montebello Drive near Albert Street in Woodhaven?
No, sir, I don't have a car to get out. I
Where
never
were you?
home probably.
Oh, wait a
I
minute.
believe that's the address. I believe the address in question was where the complaining witness was located.
Okay.
This involving sending, receiving text messages.
Okay. Okay. So what did you do? What kind of messages did you send? Did you threaten her?
No threatening messages. We're currently in a custody dispute. Judge Heston signed an order to give my son back. They did give my son back, and for 52 days they kept him from me. And it was just 52 days of being angry, but.
So you angry with, this is the mother of your child too?
The mother of my son's dad,
Yeah.
my son's parent,
I see.
yes,
So she's the one you were alleged to be stalking.
yes.
And what did you send her when you were stalking supposedly? What kind of text messages? What kind of phone calls?
No phone calls, all text messages, but they were, my son's dad had been lying throughout the.
So you started off sending her a couple, correct? And at any point did she tell you to stop communicating with her?
Probably around March 6th.
And
After March 16th, did you continue to send her unwanted text messages?
Yeah.
And did the police have to become involved as a result?
Yes.
Okay, so the police had to become involved because you're charged with a crime. That's satisfying.
are you on probation or parole?
I'm Judge Heston's.
Were you on probation or parole at the time that this offense occurred? Back on March the 16th?
Yes,
You understand if you plead guilty here and you were on probation on March 16th, that this case would be deemed a violation of that probation could be revoked. You could be incarcerated as a result of this plea and conviction. You understand that? I can't hear you, ma'am. Anybody, you still wish to plead guilty?
yes.
Yeah, all right. Nobody's forced you to plead guilty? All right, I'm gonna accept your plea to that charge. I'm gonna order a pre-sentence report. I'm gonna give you a sentencing date, and I'll take it under HIDA, September 22 at 8:30. July 22 at 8:30. I'm sorry, July 22 at 8:30. Go get your notice and you're all set, okay? And you can leave, but before then, you have to talk to probation today, okay? Good luck.
Thank you, Your Honor.
Cameron, thank you. Cameron Thomas Brad, 26W8435536.
Don't.
I don't know what's going on with you.
I-
You've been
so I
coming in
don't.
front of me and Judge Hessen repeatedly over the
I
course of the
know,
last
I
3
don't,
weeks.
you won't give me a chance right now. I told you what's up. I get $1,200 coming and I got buddies that are gonna help me too with vehicles for the time. I'm buying a vehicle anyway, so I can get my social security in 1 month.
Anything you'd like to say, Mr. Carmen?
Your Honor, I would ask for consideration of an immediate sentence and credit for time served, please.
Anything else, Mr. Sorrell?
Yes, sir. I told you what's up. I'm getting $1,200 social security when I get out of here, and for sure, and I'm getting out of Woodhaven. I'm buying a place in Taylor. So
Told me that
you know what I
stuff
mean?
for 5 years now.
What? I mean, I'm doing it. See, you never give me a chance anyway. You don't give me, here's what's up. You never give me personal bond ever either. Never. One time. That's
Mr.
it. You
Sorrell,
don't even give me a chance.
Mr. Sorrell.
You know
You're in
what's going
front.
on? I'm getting out of town. I am. You can't, you know what? See, you won't even take a chance on it. I need to get out of here, man. Saturday, I was supposed to leave, man. So, oh, man.
100 fines, 100 costs, 75 victims' rights, $50 justice assessment, 325 or 7 days. I'll give you credit for time served on that case, 26W843-401. You'll serve out your jail term on the other and be released. I just don't understand why you won't stop trespassing.
What did you give me? 7 days then?
No, you're all set on this one. You just have to finish out your jail term on the other one.
Oh,
Good
and
luck.
I'm done, right? Saturday,
Good luck.
I'm done then.
Good luck.
Saturday, I'm
Thanks.
done, right?
Okay.
All right, I'm done Saturday, then I can walk out of here. That's the day I'm supposed to walk out, the 18th, yeah.
If that's what they told you, I gave
Okay,
you
good.
45 days.
Okay, good. That's what they told me. You gave me a chance this time. You watch. I will prove to you, man. And all I do is witness for Jesus. That's why I'm back in here anyway. There you go.
All right,
Yeah,
good
everybody.
luck, sir.
Everybody,
Salitha against Alex Richard Sobolak, file number 25W84092.
Michael A. Carmen, 73824, but at the front of your honor.
Your name, sir?
Yeah.
Alex Richard Sobolak.
Okay. You're not just in custody. Well, no, he's not in custody on this at all.
No.
All right, I'm gonna go ahead and adjourn it. Jimmy, we'll adjourn it 2 weeks, okay, Heather?
Okay, Judge, so we either have, because of this add-on docket, we have the 22nd or August 5th for Woodhaven.
Make it July 22nd at 8:30, okay? Or you want me to make it later because it's in custody, and maybe I'll make it 9:15, okay?
That would work, good, Judge.
9:15. 9:15. Sir, good luck to you. We'll see you here then. Thank you. People against Sorrell. Gregory Lynn Sorrell, 26W842-674, 26W842-997. And that's it.
Michael A. Carmen, P73824, but at the front of your honor.
Mr. Sorrell, your name, sir?
Gregory L. Sorrell.
Good afternoon, Mr. Sorrell. Does he stand mute, waive formal reading on these?
Yes, sir, on both matters.
Not guilty pleas are entered, and now, as I understand it, he's gonna plead on. I can't read the, looks like he's gonna plead on this case, May 27 incident. He's going to plead his charge to trespassing, and then they're going to go ahead and dismiss 26W842-997, right?
Correct, your honor.
Is that what you want to do, sir?
Yes, and I want to explain about, I was in jail on my birthday already, and I've been here 30 days almost already, sir. So I
If-
think I should be able to get out
if
the
you plead guilty to the-
18th this Saturday, which was planned on.
If you plead guilty to the trespass charge, the possible penalties are up to 500 fines, 90 days jail, costs are all those. If you plead on that on 2874, offense date May 27 to 26, I'll go ahead and dismiss on motion of the prosecutor the May 24, 26 incident. Do you understand that?
Yeah, I understand that.
Understand, you are presumed innocent. They have to prove you guilty beyond a reasonable doubt. You have the right to a trial by court or jury. You have the right to question their witnesses, to bring in your own, to use the subpoena powers of the court to bring in those witnesses. If you plead guilty, you'll be giving up all those rights. You'll be giving up the presumption of innocence, waiving the requirement that they prove you guilty beyond a reasonable doubt, your right to a trial by court or jury, right to question witnesses at that trial, and right to bring in your own witnesses. Do you understand that?
Yeah,
To the charge trespassing from May 27 to 26, how do you plead?
guilty.
Were you at 22470 Allen Road in Woodhaven at Super Suds?
Yes,
Had you been told that they did not want you there, or had been trespassed from the property by either signage or letters or communication from the owner?
yes.
And you went back anyway, right?
Raining and snowing, yeah, and had to use their facilities to dry my clothes and spend money there, yeah. There you go.
Right now, are you on probation or parole?
No, nothing.
Anybody force you to plead guilty?
No.
Plea is accepted to that charge. I'm going to dismiss on motion prosecutor 26W842-997. Heather, can you pull up Mr. Terrell? I'm not sure when I sentenced him on the last case.
Now, let me take a look here, Judge. I want to say it was 45 days.
I gave him 45, starting when?
Yes. It was, I believe that was the 17th of June.
So he
Right.
served 14, he served 27 days, including today, it sounds like, right?
I just want to double check. I'm going off. I just got to find the correct. I'm almost positive, Judge, that that's correct. I just want to make sure. I haven't hit all the right cases here. Sorry.
And can you give me the case number of that one?
Yep, that one's 26W 843401. So yes, it was 45 days beginning June 17th.
Chanel Wilson Tallison, 26W841-681. Your name? When did you get here today?
Okay. The name was, 2 to 150. But I was trying to explain to him what happened. My mother called me, just told me my uncle was rushed to the hospital, his blood pressure is 700, and his sugar 15.
Slow down. I can adjourn this for you. You want me to adjourn it?
Yeah.
You live in Woodhaven, right? All right, I'll just go ahead and adjourn it. I don't think I've ever said a reindeer, right, Heather?
That's correct, Judge.
Just adjourn it. You set a date. Go down the hall. They'll give you your date, okay? When you go to the hospital. I'm sorry for that. Good luck. Donahue. Go right down and talk to those ladies. Daniel Ryan Donahue, file number 6W841-850.
Michael Lee Carmen, 37384. I'm going to have to defend your honor.
Your name?
Daniel Lyon.
All right, so what are we doing on this one? He wants an adjournment, right?
First card.
Is that right, sir? You want that?
Yeah, sure.
All right, first of all, let me give you a $500 personal bond. You cannot leave the state without the consent of the court or violate any law. You must appear in court as directed, okay? So I'm giving you a personal bond on this, but there are bond conditions. No contact with prosecution witnesses. You're not to enter 23800 Allen Road or any other wall marked. You're not to enter 23800 Allen Road in Woodhaven or any other wall marked. $500 personal bond. You cannot leave the state. You cannot violate a law. You must appear in court as directed. You have to go over to the Woodhaven Police Department to be fingerprinted and photographed today by 3:30. Any reason you can't get there by 3:30?
No, I'll go there as soon as I leave here.
All right, so you have to go over to the Woodhaven Police Department to get fingerprinted and photographed. I'll give you a new pretrial date, and that will be when?
We could do July 22nd at 9:45.
July 22nd at 9:45. If you want a court-appointed lawyer going forward, you're gonna have to fill out a petition for one, okay? Do you work?
Yes,
Where?
I just started my own tree service 2 months ago. I've been doing tree work for 7 years, but I finally went out and bought my own equipment, so.
But wait a minute. You did my tree once,
Correct.
and then you were in front of me on that other case, and you
Yes.
didn't show up on it.
Years ago, yes,
So that's why I thought,
with you had put me in drug court, sobriety court.
and you
Yeah,
didn't show up.
yeah, and there's issues before in the past, but I'm on probation with passing. I can't say, Your Honor, I've changed my life around. I'm doing great for myself, and
Doesn't look like you're doing too great. You keep getting yourself in trouble. If this is doing great and you turned your life around, I'd hate to see what happened if you didn't turn your life around. You still got a warrant out of Southgate, out of Detroit, out of Southgate, out of Lincoln Park, and out of Monroe. So 2 out of Southgate, Monroe, Lincoln Park, and Detroit. Go take care of those before you come back.
okay.
Fill out a petition for court-appointed lawyer. We'll see you here. Good luck. Destiny Henry. Make sure you go over there and get fingerprinted. I filled out the order, Heather. Destiny, Danier, and I also have 26W843531. Your name?
My name is Ken.
They're gonna dismiss the littering. You're going to plead to the civil infraction of pedestrian violation, right?
Yes, that's correct.
Jaywalking on Rygate near Heritage Drive.
That's what.
To that charge, responsible or not responsible, pedestrian violation.
Oh, responsible.
I'll accept the plea. Fines cost of 75. Littering's dismissed. You're all set.
I have just one question for you.
Sure.
I actually heard that you may know somebody that was related to me, my grandmother. Her name is Audrey Jean Brad.
Yeah, but I can't do anything for you.
Yeah, I know. I wasn't asking you to do anything about that. I just heard. Just wanted to say.
I mean,
she was a big part of my life, so I was just wondering.
yeah.
He actually wanted to know if you knew Richard Brad or Audrey Brad, which
Yeah.
one you knew more. And I thought it was my mother, Audrey,
Yeah.
because of the dry cleaners, but I'm mentioning.
No. Where did Audrey Brad live at?
She used to live at 2211 Medford Street. It's right
Right
in-
here.
Yeah, right on the corner of Medford and Harrison.
Yeah.
I mean, I haven't seen her in decades. They had a big sign up for me when I ran when I was a
Yeah.
kid. I was a kid then.
She actually passed away in 2023.
I'm sorry about that.
Yeah, she was one.
Are you gonna stay out of trouble?
I'm trying to get myself a job right now.
What, did you graduate?
Yes, I graduated with a diploma.
When's the last time you worked?
Friday. Actually, I lost my job Friday.
How'd you lose your job?
I was about to go do some comments that were made about another associate, because they were.
About what?
Another coworker of me, of mine was harassing me, and I just made some comments under my breath, and then my boss asked me what I said, and I said it again. Probably shouldn't have said
Where were you working?
it. It's like with Walmart.
Where?
Walmart, right over there on.
Go ahead and set it for discovery cutoff dates and witness list due dates and that type of thing. Okay, ma'am? So here's what I'm gonna do. And you can feel free to talk to Mr. Levine at any time about the case and see if you can resolve it. Discovery is permitted. It's to be completed by September the 15th of 26. No motions will be heard on the date of trial. All motions for summary disposition have to be filed and heard not later than 20 days before the trial date. Nobody demanded a jury trial. You do have to file a witness list disclosing the names of all your witnesses by August the 15th. I'm putting down a 1/2 hour for trial. There will be no settlement conference date. You do not have to file a trial brief. If you choose to file one, you have to file and exchange it not later than 7 days before the trial date. The trial date will be on October the 20th of 26, and that'll be at 10:30 a.m. Do you have any questions? You understand what I mean by discovery? If they have documentation that you think you would like that will bolster or help your case, you can request it in writing.
I brought everything today. I'm thinking that I was gonna do that today, but I have to wait.
Well, this is just a pre-trial. And you have the right to conduct discovery now. What I'm doing is for 60 days, so you guys can exchange information. And if they have an objection, they'll tell you. But I'd suggest you call Mr. Levine. You're saying that the apartment was in an unsanitary and uninhabitable condition?
Yes,
Let me see, do you have your photographs?
I had to flash drive the video, and I gave you guys photos. Leaving April.
Did you check into this, Mr. Levine?
Yes, I did. And she never took possession of the apartment. And my understanding is she was planning on moving in with another unauthorized occupant. When that came up, that's when all these issues arose. So these are move-in costs. She never took possession of the apartment. At issue is whether or not she would owe these move-in costs. We believe she does. And if she believes she doesn't, then I think that is a triable issue for Your Honor.
Well,
Did you say
you didn't file a counterclaim, did you?
No, just an answer.
Okay. All right, look, I'll just set these dates. You guys can talk, and if it's not resolved, we'll simply have our trial on October the 15th at 10:30, okay?
October the
Yeah,
15th at 10:30.
Anything else, ma'am? Here you go.
October 20th.
Yeah.
What'd I
October
say?
20th.
What'd I say? I'm sorry.
You're switching it up on us.
October the 20th at 10:30. It
Thank
was
you.
off a week. I'm a little rusty today.
20th, 10:30. Got it.
Have a good day. Thanks. And I'm gonna call your Bodgers case as soon as he gets here.
Well, it's an
We've got
8:30
an-
case, and I've got some time. I got court. So. how long
Jen,
am I
did
gonna
you
wait?
say something?
Yes, Judge, Lisa has emailed the jail because we were questioning why he hadn't been logged in yet. So we're waiting for a response.
An 8:30 case, Your Honor, and I've got court, and
You,
if you'll allow me to go on mute, and I'll come back when I can, but this is,
come on. Yeah, go ahead and do what you gotta do. I mean, I don't know why.
it's an 8:30 case involving allegations where the defendant beat up his neighbor with a baseball bat. It was filed in January. I think we've had hearings going back since February, March, April, May, June. Now he's in jail probably for a good reason. It might be appropriate, Your Honor, that we enter a default judgment. But
Well, how can I do that?
No
Look.
answers, no answer's been filed, no attorneys appeared for the defendant, the defendant's not present,
Second.
been written to be.
Hang on a second. I've taken the position, I can't remember who was appearing from your office. I believe it was Mr. Landman.
Mr.
Am I
Landman's
right?
on Mr. Landman's on personal leave right now, but yes.
Okay. Well, that's fine. I hope everything's okay with him. He's a good man. But the fact is that I was the one who said we cannot proceed on a termination of tenancy case when somebody would be incriminating themselves. I cannot proceed to a trial and have lawyers peppering questions at him when when the incident that's
I'm not asking for a
the
trial.
both is the felonious assault issue. And he's in custody and this jail's screwed up. Again, I believe this is the second time. Am I right or wrong, Jennifer?
Your Honor, this is the first time I've attempted to write him out. Last time we were unaware he was in
I
jail.
can't, I feel for you. I feel for you.
I'm not asking for a trial. I'm just asking for a default judgment. And
Well, how can he's in custody. How can I do that? That's not fair.
notice was sent, but Your Honor, it's not fair that his neighbor got beaten in the head with a baseball bat and was
Well, I
hospitalized.
don't, listen, it might
The
be.
other neighbors have, it's less of an issue because he's in jail, but at some point, I think we do need to entertain a default judgment.
Well,
If you want me to wait for the jail, I can wait, but I need to get to another one, so if I could come back.
but listen, Mr. Levine, I don't know when the trial is scheduled. I'm not going to go forward or make him go forward before the criminal trial. I'm just not going to do it. I understand your frustration. I get it. If this was for non-payment of rent, it would be a different story. It's not fair for a judge, and it might very well be overwhelming evidence. I don't know. It could be. I think I did preside over the preliminary exam, I think. But maybe it was a waiver. I don't remember, but now they had a competency exam, I think. So I'm just gonna put it out again. I'm sorry. Give me a date 3 weeks out. We're gonna give it August. Is it the third, Jennifer?
Third
August
at 1 o'clock.
at 1 o'clock. If you feel that strongly and you want to write a brief and tell me why I'm wrong, I'll be glad to write, I'll be glad to review it. I am not always right every time, but I just cannot, under these circumstances, enter a default judgment when his failure to appear is based on the fact that he's in custody and the county didn't put him out there. Just can't do
Connor,
it.
if we serve him with this notice while he's in custody, would you entertain a default judgment the next hearing?
Serve him with what notice?
Notice to appear for August 3rd at 1 p.m.
How can I, in this case, for a termination of tenancy, I can't do that. If you think I'm wrong, you can file a brief. And I'll be glad to listen to you, read it, think about it. But I just can't imagine me changing my mind on this. This is not right. And I'm not saying that I feel sorry for him in the least, especially if he's convicted of a felony. But
A violent felony involving his neighbors, the allegation.
I
We'll
know,
be
but
here on the 3rd at
wait a
1
minute,
p.m.
Mr. Levine. You and I always get along good, but there is this thing, as you know, there's this thing called the presumption of innocence. This is the United States of America. They have to prove the case beyond a reasonable doubt, and maybe they can prove it beyond any doubt whatsoever. But I can't just make the assumption because there was a charge levied that he's guilty. I mean, geez, if I do that, you should even want me off the bench.
I'm not asking you for a guilty conviction, Your Honor. I'm just asking for the civil judgment, and it's a different burden of proof. It's a civil, it's preponderance. Oh, thank you. Well, I had to ask, and I appreciate you.
Thanks a lot.
We'll see you on the 3rd, 1 p.m.
Thank you.
Great. Yeah.
Excellent Repair LLC versus Waymo Freightliner LLC. Do I have Excellent Repair LLC here?
That's right.
Are you guys opponents? Oh, you're both for Excellent Repair. Okay, where's Waymo Freight LLC? Your name, sir? You got to spell it for me. Will you do that, please?
MOHAMME.
And your last name, more important.
ALALYAWI.
Okay, thank you. And ma'am, what is your name?
Signal Garage,
Can you?
YFARAJ.
Thank you. Jennifer, was there proper service here?
Your Honor, it was served by certified mail. Should be printed and attached to your packet.
Well, somebody signed on behalf of the company at 419 Cedar Avenue South in Minneapolis, Minnesota. Who's the principal of this? You both or what?
That's fine.
Oh,
We're both partners and.
well, then I'm gonna ask you both to raise your right hands. You solemnly swear or affirm under penalties of perjury that the testimony you'll give in these proceedings will be the whole truth self you got, sir?
Yes.
Ma'am? Okay, so what happened here? Who wants to tell me?
So this is a customer that, we usually, do work for every now and then. He's not from there, he's from Minneapolis. He has a fleet of, I don't know, multiple trucks and he always comes to us and, we always fix his units. So he called us, he was all the way in Monroe, Michigan. He said my truck was overheated. One of my guys went and, did a road service for him. The water pump was leaking everywhere.
You did work to the tune of 3,127.10, right?
That was before that. That was, that's how it all started. I was talking, well, on this case, 3,000, yes, that was in the shop, but before that, went and did a road service for him. And we changed the water pump, but the actual water.
He didn't show up. They didn't show up. Listen, did you bill them 3,127.10?
Yeah, we fixed his truck, he took his truck and he left, he didn't pay the bill.
Yeah, that's terrible.
We contacted the driver and the driver said, he told me, hey, if you have an issue with him, I have an issue with him too, he's not paying me either.
Great.
So.
Jennifer, give me a judgment. You're gonna get a judgment here for 3,127.10 plus you have a $70 filing fee plus you have a certified copy charge of $12. So that's 82. So that should be 3209 10. Do you have any other out-of-pocket costs? Why don't you guys wait around? Jennifer, will you prepare that judgment?
I'm typing it now.
312710. And then $82 in filing and service fees for a total of 3209. 10. Wait around, I'll sign it. As soon as she brings it down, I'll have my court officer bring it down. And then you're gonna be all set and take that copy of the judgment. I'm sorry, you're gonna have to go through that.
Thank you so much.
Have a good day and good luck to you both. All right, what else do I have? Okay, counsel, I'm gonna call that Midland Credit versus Lynette A. Cloud, 2601416. Good morning, Mr. Cicchini. Your name?
Good morning, Your Honor. Philippe Cicchini on behalf of the plaintiff Midland Credit.
I'm sorry, I'm mispronouncing your name, aren't I?
It's fine, Your Honor. People have been doing it my whole life. You are completely free and clear of any of any guilty feelings. You're fine.
Apologize. What'd
No
you
worries.
find out about Lynette Cloud?
Your Honor, thank you for giving us the time to do a little research. So yes, we found on the process server's website that the following comment was entered by the process server. This is Ranco Rancilio is the process server in this case, Your Honor. The note that the process server entered was, please note, server reported threat at this address after first attempt. We will not be sending anyone back to this address. We will be attempting via certified restricted mail. And then there's the following note on 4/19 at 12:39 p.m. No answer at the door. There's a car in the driveway, left notice. The process server then noted.
Wait, give me 1 second. Hang on.
Yes, Your Honor.
I'm gonna
Yes.
take this right good.
Yeah.
All right, go ahead.
Okay, and then the process server left the following annotation. I received a telephone call from a male extremely threatening from a number 313-622-5897. Just a side note, Your Honor, I did go into the defendant's account. That number does match up with a phone number we do have for Lynette Cloud. So again, resuming the note here, I received a telephone call from the male extremely threatening. He told me to stay the F away and threatened bodily harm if I return. I wasn't certain who it was, so I sent him a text and I told him in the text that you asked me to stay away, but I don't even know who this is because you didn't tell me your name or address. So he sent me that information, and that is how I knew it was for this defendant
Does the
at
summons
this
expire?
address.
When does the summons expire?
Oh, okay. Let me see if I have that, Your Honor. I'm sorry. We're having technical issues where I can't pull up PDFs right now. Let me see if I have that information.
Oh, I see it on the notes here. It says expires September 4. I'll grant your motion. Send your order in again. If we do we have it? Do we need him to do that again?
Judge, we should have it in pending, waiting for this hearing. So
I'm
I'm
gonna go ahead
checking
and
right
sign it, and if Jennifer, follow up on that with me, please. Make sure I sign that. If we need more information, not more information, but if we need another order, we'll contact you. Otherwise, I'll sign that one.
Okay.
Okay?
Appreciate it, Your Honor. Thank you. Have a great day.
I see what happened now.
Okay.
I didn't have that information available to me.
For your
Thank
Honor,
you.
just for my information, so are you, this was a hearing that was scheduled for this morning at 8:30, is that correct, Your Honor? Is it, or the clerk, if someone can?
Yes, Your
confirm
Honor. Yes, it was scheduled for 8:30. We mailed notice to your office on that.
Called you,
Okay,
Your
yeah.
Honor. You just got the motion, Mr.
that?
Sorry, Your Honor.
Appreciate it. Okay,
Good
yeah,
day.
we'll look into it, why this was missed by any counselor or hearing counsel this morning. Obviously, we don't want that to happen in the future, so we'll look into why this was missed. So our apologies for that one, Your Honor.
No problem. Thank you.
Okay. Thank you. Have a great day.
Jefferson Capital versus Joe Tostage, 2600218.
Good morning, Your Honor. Suzanne Barda, P65425 on behalf of the plaintiff Jefferson Capital.
Is Mr. Tostage here, Jennifer?
I don't have Mr. Tostage or his counsel.
Guys, you can go right down the hall. I signed that. Thank you. He's not, the lawyer isn't here?
No, Your Honor. I'm showing Mr. Langston as defendant's attorney on that.
What do you want me to do, Mr. Barta?
Your Honor, today's the date time set for a motion for summary disposition. I will say that I have hundreds of files with this third-party debt consolidation firm who hires Mr. Langston. He has never opposed any motion out of the hundreds that we filed. If our motion is granted and a judgment enters, that's not going to stop this from resolving with the debt consolidation firm who is actively contacting our office, and we've had numerous conversations with. So today plaintiff is respectfully requesting that our motion for summary disposition move forward.
Grant your motion. I'm gonna go ahead and grant your motion for summary disposition. There's no genuine issue. It's any material fact. You're entitled to it pursuant to MCR 2.116C9 and 10. Just give me the breakdown, if you would, Mr. Barta, please.
Yes, I'm pulling up the motion here. I just want to make
Take your
sure that
time.
it was attached. I don't think it was attached, so I will have to submit an order for entry, and so the
Got-
court.
I've got it's 357560. Got a filing fee of 75. You got a service fee of 41,040, and you also have the statutory attorney fee coming up 75.
We do not charge the statutory attorney fee. We do charge the $20 motion for summary disposition fee.
So
the only-
you've got,
Your Honor, I'm sorry, I walked away from my computer to give that copy and Mr. Langston has logged in.
Oh,
Mr.
perfect.
Langston, your name?
Good morning, Your Honor. Matthew Langston.
He's argued his motion essentially.
And we have no opposition to their motion, so.
I'm gonna grant the motion. He's entitled to principal sum of 357560. He's got 11604, 13604 in court costs. It should be 371164. Is that true?
That's
That-
true.
That sounds correct to me as well.
All right. Judgment will enter in that amount. I'll ask you to send that over, Mr. Barta. You two have a
Thank you,
good
Your
day. Thank
Thank
you.
you, Your
too.
Honor.
Thank you.
Do I have J&B Medical Supply? Jeez. Versus Deanna McLean?
Yes. Christina Codrington for the plaintiff.
Good morning, counsel. How are you?
I'm good. How are you?
Ms. McLean, your name, ma'am?
Hi, Deanna McLean.
Any resolution on this?
The account's been paid in full. Our office is filing dismissal.
Your office is going to file a dismissal?
Correct.
Did she pay in full?
Yes.
So you're going to submit a stipend order to dismiss
Yes.
with prejudice, correct?
Yes.
So you understand and agree to that, ma'am?
Yes.
I mean, it's in your benefit, and she has your permission to sign your name to that document?
She's already signed it herself.
Oh, perfect. All right, send it over. Have a good day, everybody. Keep
Thank you.
smiling. Good luck. Thank you.
Thank you.
Wouldn't you tell me again about Aloha?
I believe he may be in the courtroom. He was a Samsung device we couldn't connect with. So he was going to come here to the
Son,
courthouse.
Aloha?
Mr. Sings.
Come on up here, sir.
To the podium.
2601776R. Your name, sir?
Samsi Idemi.
Nobody showed for defendants, right?
No, Your Honor.
Did they file an answer to the complaint?
Yeah, they got say yes.
I don't know why they didn't show up. There might be a valid reason and they might not. Defendants failed to appear. This is a pretrial. Defendants failed to appear. Default judgment will enter. I'm going to give you the following amount. You prayed for and you are entitled to $4,075 in a principal sum. And then you had court costs. You had $110 in filing and certified fees. So 70 filing, two charges for certified mailing, 18 and 12. So you have court costs there in the amount of 100. Plus, I think that's it, isn't it, Jennifer? So I'm gonna enter a
Judge will
judgment amount of $4,175 in your favor and against the defendants. They were supposed to be here at 8:30. I know you had a problem with your device. You couldn't connect, and so we told you to come in. You're here. They're not. You win. We'll send the judgment out to you, okay?
Thank you, sir.
I wish you well. Good luck. Thanks. Is that it?
We have a defendant on Zoom who lives in Detroit. She has 3 warrants. And she wants to be here.
She can't make it here? Well, she's gonna have to make it here. Who do we have on?
Her name
who's-
is Ashley Stevens. She's in Zoom. She said she has no transportation from
Where's she
Detroit.
live?
She's in Detroit, she said, Your Honor.
How old are the cases?
2022.
Oh, well, hey, if you can't find a time to get here, she's gonna have to show up. Give me a break. She's got 3 warrants from 2022. Come on. Tell her the judge said she has to appear in person. And if she doesn't, the warrants are gonna remain in full force and effect. Thanks.
You're welcome.
Release the garnishment that was at issue for the objection. That was e-filed today.
Okay. All right. So do you understand that and agree to that, Mr. Perez?
I am in agreement with those statements, sir. I agree. Yes, Your Honor.
So again, you have to pay the $2,089.35 by June 24th. And so long as you make that payment, plaintiff's counsel is going to file a satisfaction of judgment. And then the garnishment has been released. He filed that this morning so that your wages will not be garnished or your bank account.
Thank you, Your
You
Honor.
understand that?
Yes,
Okay.
Your Honor.
Anything else that I need to add, Mr. Johnson?
Nothing for me, Your Honor, no.
Your
Anything
Honor,
else? Yeah.
If I may, I'm working on that Garn release right now. And if he needs a copy for his employer, other than us mailing it, he can stop in and get one.
Thank
So do
you.
you understand that? That'll speed up the process then, okay?
I do, Your Honor. Thank you very much. I appreciate your guys' help.
So you can call the court. I'm gonna have to sign that, obviously.
Judge
you
is signed by a clerk. You don't have to.
Okay, good,
It's
good,
just the
good,
Garn
good.
release. Yeah.
Right, okay, perfect. So you can come up there and get it now. Thank you.
Thank you.
All right, thanks, Mr. Johnson. Have a good day, everybody. Thanks.
Thank you.
Source Realty Management versus Megan Galoro, 2504376.
Good morning.
Okay. Good morning.
Good morning, Your Honor. Attorney Carrie Zanon on behalf of plaintiff.
Good morning.
And your name, ma'am?
Megan Galoro.
Any resolution on this one, Ms. Zanon?
I do believe that we have a resolution. However, can we have an adjourn date? Maybe like give us 60 days discovery. I just need to speak with my client and then I will reach back out to the defendant. We've talked about resolution in a payment plan, Judge.
Okay, let me go ahead and do that. Give me your P number again, if you would, Ms. Zanon.
67390, Your Honor.
And Ms. Galoro, you understand what she means by discovery?
Yes.
All right, so I'll give everybody 60 days. So we're gonna make this April, we'll make it May the 24th of 26. I'm not gonna order ADR. Nobody demanded a jury. I'm going to give you guys a trial date in early July. I'll put down 1/2 hour for trial. And witnesses are due by May. May the 1st, I'll make it. May the 1st. You don't have to file a trial brief. If you choose to, it has to be filed and exchanged not later than 7 days before the trial date. We're going to put everything right in here in the pretrial order that will be mailed to you, but I'll give you a trial date right now. No motions on the date of trial. All motions for summary disposition have to be filed and heard not later than 20 days before the trial date. So why don't you give me a trial date, Jen, and I'll go from there.
July 13th at 10:30.
What day of the week is that?
It's a Monday.
Good. You said at 10:30?
10:30, yes, Judge.
July 13th at 10:30 will be the trial date.
Thank you, Judge.
Anything else anybody needs to bring up on this one?
No, Your Honor.
All right, thank you very much. Have a great day. Any
You too.
questions, Ms. Galoro?
So do we have to go to trial if this gets resolved before then?
We do not.
No,
Oh,
I'm just setting a trial date if it isn't resolved, then we're gonna go to trial.
Okay, understood. Thank you.
Okay, good luck to you.
Thank you very much.
Here you go, Sadie. Just leave that there. LVMV funding versus Rachel Snyder, 2505163.
Your Honor, there's actually a companion file as well, if you want to call that one at the same time, ending in 6-5.
Yeah, I have 2505163, and I also have 2505165, LVMV versus Rachel Schneider.
Good morning, Your Honor. Brian Gruen, GROEN, P number 56673, on behalf of plaintiff.
David Lady, P269.
For Ms. Snyder.
I'm here on behalf of defendant. Can you hear me, Judge?
I can't hear
Can you hear me?
not a word, and I can't see you.
Can you hear me now, Judge?
Not very well. I can hear you, but not very well. I need you to start your video first.
I'm having trouble with my video. I don't know why it's just your court that I have that problem, but I do. But I can hear you and hear Mr. Groen. Mr. Groen, I
Gotta have you speak louder, get closer to the device.
have.
Turn your volume up. Working? Are you out of Las Vegas?
No.
The attorney of record is, Your Honor. This is just appearance counsel for Jocelyn.
Yeah, I've just never had him in here before, I don't think. David Lady is his name?
That's correct, Your Honor.
Nobody can hear me, huh? I could hear Mr. Groen
I
earlier.
mean, I can hear you okay, but not really. I don't want to have to strain too much. Where are you at? Where are you at right now?
At my home in Onstead. I work out of my home.
You can't start your video from the bottom left-hand corner of the screen?
No.
Judge, I was gonna say, on my end, it shows this video is started, so I'm wondering if he's got a camera issue.
All right, let me just ask you guys this. Are you close to resolution on this at all?
Your Honor, the defendant is working with a debt settlement company, and we actually sent me offer on one of the two that I think we're halfway close on one, but I have not had any correspondence regarding the companion file. So pretty much like the former case you just called, we're just looking for 60 days discovery, and we're hoping prior to us even having to file a motion for summary, we'll get these resolved.
I agree with that, Your Honor, and Mr. Groen.
Okay, hang on one second, guys. Let me just, I never consult, these rise out of two separate debts, is that it?
That's correct, Your Honor. Two separate credit cards.
All right, so I'm gonna do. What's your P number, Mr. Lady?
P26968.
Oh my God, you've been around a while.
I have my 50th anniversary coming up next month, Your Honor.
Well, congratulations to you.
Thank you.
Your Honor, that explains the camera issue.
Listen, I get it. I was thinking that the whole time because I know how I am, and he's got a few years.
Sorry, that
Secretary's been working on
might
the
have been
problem.
inappropriate. I
I
apologize.
fire my secretary, but it's my wife, so I can't do that. So bear with me.
I got it. Okay. All right. Look, I'm just going to prepare two separate orders here. We'll send them out. I'm going to make them 1.5 hour for trial. Jennifer, I'm going to do the same thing as I did on the last one. Witness list due May the 1st. You don't have to file a trial brief. If you choose to, you have to file and exchange it not later than 7 days before the trial date. Discovery's open until May the 24th. No motions on the date of trial. All motions for summary have to be filed and heard not later than 20 days before the trial date. And again, I put this in every order and I don't say it a lot. All motions and responses, as well as trial briefs, have to be accompanied by a second copy. But I guess that's a little bit obsolete too now, the way everything's being done. So I will go ahead and send these out. And I'm gonna just do the same thing. Give me the same trial dates.
July 13th at 10:30.
July 13th at 10:30 will be the trial date on both of these cases, okay? And I'm putting down 1/2 hour. So we're just gonna basically do the same thing here on these, Sadie. We'll just mirror them. I only filled out. Anything else, Mr. Lady?
No, Your Honor, thank you.
Mr. Groen, anything else?
Not on these, Your Honor. Appreciate
Well,
it.
congratulations to you, Mr. Lady. When is your 50 years actually? Is it November?
Yes, but they're having a luncheon in May in Plymouth, I think.
Well, congratulations. That's a long time.
Yeah.
Have a great day. We'll see you guys later. Thank you very much.
Thank you, Your Honor.
Credit acceptance versus Sarah Case Shoup, 2505167.
Good morning, Your Honor. Cezanne Barda, P65425 on behalf of Credit Acceptance.
All right, ma'am. Your name, please.
Yes, good morning, Your Honor. Sarah Kelly Shoup.
Okay.
This is
So,
resolved, Your Honor.
say that again.
This is resolved.
Oh, good. Tell me.
Ms. Shoup has agreed to pay $1,950 on or before July 24th, 2026. That's going to be in the form of a conditional dismissal. I've advised her that I would put those terms on the record, and Your Honor can ask her if I have authority to sign her name to that conditional dismissal. I believe she's going to give me that authority, and we will submit that, and then she'll get a copy. If she wants to dispute anything in there, she can at that time.
So do you understand what he just said, ma'am? He's telling me you're going to pay $1,950 on or before July 24, 26. This will be in the form of a conditional dismissal. The case will be dismissed at this time. If you do not pay that amount on or before July 24th of 26, it will convert to a judgment. And then they'll have the opportunity to execute on the judgment, garnish wages, etc. Do you understand all that?
Yes, I do, Your Honor.
You agree to those terms?
Yes, I do.
Does Mr. Barta have your permission to sign your name to that document?
Yes, he does.
Do you have any questions for me at all?
I do not. Thank you.
All right. Anything else, Mr. Barta?
No, sir, that's it.
Have a great day. What looks different about you? You getting better looking, or what is it?
No, I think I'm getting, my hairline is really far back. That's what's happening.
Oh, come on. All right. Have a great day. Take
All
care.
right, thanks. You too.
I appreciated your comment on that one too. I got to tell you, that was perfect.
Have a good day.
You too. Okay. What do I have now here? I've got, let's see, a citation.
Stop the stop sign, make a left-hand turn. However, on Seneca, she was traveling south at an above speed limit rate of speed. He approximated in the 40s, where she would be impossible for her to stop without hitting something if they turned in front of her. But her speed was so high, as he turned, she reached him, T-boned him, and he was pushed up onto the lawn where he was less than 25 feet from a home.
Okay. So please listen, Ms. Wilson. I'm not here to quarrel with you.
I understand.
I'm just trying to help you.
I agree.
If you want to take 5 over, he's willing to offer it. No, wait, I want you to listen. Don't just please listen. You don't have to do that. If you want to go to the hearing, I'll listen to everything. You might win, you might lose. If you win, there's no points, no fines. If you lose, then it would go down as a driving without due care and caution, which is a 2-point civil infraction. So it's up to you. If you want to take a couple of minutes to confer with, who's this gentleman again?
I've been with him for 36 years.
Okay, well, if you want to confer with him, talk to him. I saw you looking at him. I don't have a problem. But not from there. If you want to go talk to him, I'll recall the case. I'm back up. You talk to him. What do you want to do?
Just have to take the 1 point and put on my record.
Yeah, it's going to go on your record. It's going to be 30 and a 25. You just heard him say that the witness thought you were going in the 40s.
I know you said I can't speak about it, because if I do that, I go to trial, I gotta take the one point of that, so they can't be impeding, then it will go on my record.
You damaged a car. Hey, ma'am, please, please listen. I'm not trying to trick you here. Your record is not horrible, but it's not the best I've seen. And one of the things I try to do here is if somebody's hurt in the other car or there's something more than minor damage, I don't give impede.
I understand.
Okay? You totaled the car, you put a guy up on the lawn according to the officer. I don't want to quarrel with you about it.
I got it.
You can go to hearing on the whole thing, or you can plead to 30 and a 25, and that would be a one-pointer. And since there was an accident, I'm going to charge $195.
Okay. That's, yeah, okay,
Is that what you want to do?
yes,
All right. And you're offering 30 and a 25, correct, officer?
Yes, Your Honor.
To that charge of 30 and a 25, responsible or not responsible?
but me responsible.
Okay, I'll accept the plea, dismiss the original charge. There is 1 point, and the fines and costs are $195. Okay? You can go down the hall and pay that. You're all set. Please be careful going forward, okay, ma'am?
I think you're.
Thank you very much. Thank you, officer. Have a great day. Thank you. The Hamptons versus Tamita Hake and Arif Fuzaman Talakuter, 2504826. Good morning, folks.
Good morning.
Mr. Visconti, your appearance.
Morning, Your Honor. Robert Visconti, P617564 for the plaintiff.
Good morning to you. Okay, folks, can you tell me your name, please?
Yeah, I'm Tahmida Haq.
I'm Arifuzaman Talukdur.
Okay. Do you guys speak fluent English?
Yes.
Yes.
Okay. So there's a little bit of an accent, so I'm just going to ask you to slow down and keep your voice up when you're talking, okay? I want to make sure we pick you up clearly, all right?
Sure.
Did you guys talk at all, Mr. Visconti?
We did, Your Honor, and we have a resolution of this matter.
Okay, good. Why don't you tell me what it is, sir?
So, Your Honor, we're going to enter into a conditional dismissal in this case, whereby the case would be dismissed, provided that defendants make certain payments that we've agreed upon. The total amount due pursuant to the conditional dismissal will be $1,362.49. And defendants are going to pay that amount in 3 equal installments. Well, actually, there will be 1 installment that'll be a penny less. There will be 2 installments of $454.16 on April 24th and May.
Have a great day. Thank you very much.
And Ms. Hake, I will send you a copy via email so you can take a look at it as well. Okay.
Okay.
All right. Thank you,
Good
folks.
luck, folks.
Have a good day.
Thanks. All right. Curtis Brent Hamadi. This is file number 25R513926A. So, we have something about probation violations. Good morning to you, sir. Like a spin. Look at some of the spins that I have, and then I go to probation. And I just put it right here. I look at the date it was issued, so it was issued on March the 4th, 26. And I see this. So, sir, I'm going to go ahead and arraign you on this charge. You have a charge that alleges that you failed to pay your fines and costs as ordered, balance owing $825. Do you understand the charge?
Yes, sir. Yes, sir.
Count 2, that you failed to refrain from violating the law, being convicted of disturbed the peace through this court with the offense date of December 12 of 25. And the conviction having entered on March the 3rd of 26. Do you understand that?
Yes, Your Honor.
Now, that would be deemed a non-technical violation. The violation of law would be. So you could get 90 days on that case. I'm just telling you. Violation of the law, this state. See that? You know, okay. So you could get 5 days if there is a failure to pay fines and cost conviction. because that's a technical. You've not had any prior violations. You could get 90 days if you plead guilty to the fact that you were convicted of a crime arising out of an incident that occurred on December 12th of 25 while you were on probation. Do you understand that?
Yes, Your Honor.
And did you sign, read, and understand an advice of rights form here today?
I did, Your Honor.
If you plead guilty, you'll be giving up all those rights, and we are not going to have a hearing of any kind. Do you understand that?
Understand.
You have the right to a lawyer. I'll be happy to provide you with one at public expense. Would you like an attorney?
No, Your Honor.
So you're going to waive your right to a lawyer?
Yes, Your Honor.
All right. Can you call in, Beth, please, Sadie? To the charge that you failed to pay your fines and costs of $860 or $825, how do you plead?
I plead guilty, Your Honor.
Did you fail to pay your fines and costs as ordered?
I was paying them, Your Honor, on a timely basis, and then a few months back, I had some emergencies come up.
We'll talk about that, but you didn't pay them as ordered, right?
Yes.
I'm correct?
I was starting to pay, and then I failed to make my payments.
Okay. As the count two, that you failed to refrain from violating a law being convicted of disturb the peace on March 3 of 26, how do you plead?
I plead guilty, Your Honor.
Were you convicted of disturbing the peace on March the 3rd of 26?
Yes, I was, Your Honor.
And that arose out of an incident that occurred on December 12th of 25, correct?
Yes, Your Honor.
And you were on probation on December 12th of 25, is that right?
Yes, I was.
Because I placed you on probation back in August.
Yes, sir.
Has anybody forced you to plead guilty?
No.
And you understand, again, by pleading guilty here, that would be deemed a violation of this probation, because you violated the law. And again, your probation could be revoked. And you could get 93 days, actually, not 90. This was an impaired charge. Do you understand that?
Yes, Your Honor.
You still wish to plead guilty?
Yes, Your Honor.
Anybody force you to plead guilty?
No, Your Honor.
I'm going to accept your guilty plea to that charge. Can you please pull up his register from that case? Good morning, Ms. Wiles. Your name?
Elizabeth Foster, Your Honor.
Morning, Madeline. Good morning. This is Judge Johnson. She's the new judge in Taylor. Yes,
Yeah, supervision loan.
she's going to be a superstar. I'll be calling her up and asking her questions in about 2 weeks. Okay, what do we have here? Can I see that sentencing, please? I'm sorry. I want the one disturb the peace one. That's the drunk driving, right?
I'm not sure if Mr. Hamadi's been down sentenced by Judge Hessen.
That you're in front of Judge Hessen on that.
Yes, Your Honor. I was gonna go down there after we met here.
Do you have the screening report or anything?
I-
Did you order a PSI or a screening on that?
You ordered us a screening assessment on Judge Hessen's.
I want to see the police report on the disturb the peace conviction.
Yep, I have that, but it would be attached to the blue back in her courtroom right now, Judge. I can go grab that.
No,
Here, I have it pulled up. Which part do you want to see?
I actually, that was an assault and battery that was reduced to disorderly. I think I would like to see that.
I can give you the brief,
Sure.
like circumstances.
Go ahead.
Mr. Hamadi, and his girlfriend had visited a gas station. The gas station attendant, insulted his girlfriend. It was Christmas time. She had a shirt on that said ho, ho, ho on it. He alluded to her being, unfortunately, Your Honor, excuse me, being a hoe. And the next day, Mr. Hamadi was still a little hot under the collar. And he went in, he ordered coffee at the gas station. He confronted the gas station attendant, and I think when he did get the response he wanted, he threw the hot coffee on the gas station attendant.
Oh,
Mr. Hamadi's welcome to correct me in any aspect, but that is the gist of it.
What happened, Your Honor? I never threw the coffee on them. I had them in my hands. They were thermoses with the lids on tight. I did react. I kind of I don't know what happened, Your Honor. I saw red and I shoved my coffees. They hit him and fell on the floor, but he did get splashed with coffee. That's what happened. I lost my cool and
Were you drinking?
no, I was just. He was talking, you know, kind of smack back to me and I didn't want to put my hands on him and I don't know what happened. My arms kind of jerked and I shoved the coffee at him and they hit him and they fell on the floor. And I was really unhappy with the way I handled it and,
Why'd you even go back up there the next day?
that gas station, Your Honor, was our morning routine. Literally, I'm friends with the manager there. I bring my dog there. We get our coffee every morning there. It's kind of like our home away from home. I intended to go in there and just confront the guy and say, hey, that wasn't cool. You know, what happened, what you said to my girlfriend. It didn't happen that way.
You weren't there the night before, were you?
No, she went in. I did not. She just told me about it when she came out and then I handled it the wrong way without.
Let me see the screening report on my case. Yeah, I mean, you shouldn't have gone in and
I
confronted.
should not have. Was my question.
Were there any injuries or anything? Ooh.
No, Your Honor.
You don't have the best record.
Your Honor, I don't know if you remember, I do want to make sure, Mr. Kamani, there is an extra drinking and driving on there. I don't know if you remember, he was here with his attorney. We ended up having to contact Arizona as well as Florida. So that screening assessment was corrected on the record because this was the one that on the police report it said default and it was not a conviction.
So you had one prior drunk driving in 12, right?
Yes, Your Honor.
And then, but you still had some other cases here. I mean, what do you think?
I will give Mr. Kamani a lot of credit. He called me immediately after the incident occurred to let me know that he most likely would have charges coming. Chief at the time over in Rockwood did communicate with me, sent me over a copy of the police report, and it flowed in the exact same fashion that Mr. Hamadi and myself kind of represented as far as what was in the police report. I think Mr. Hamadi is hot-tempered, but I don't think it played a role with any type of, like you had asked about him drinking. There was no indication that this was provoked by any alcohol or drug use.
Where do you work at again, sir?
I actually just got a job. I work for the Metro Parks, contracted to the Metro Parks. 1 year. So I can definitely catch up on my fines. I can make a payment this Friday.
Do you live in Rockwood still?
I do, Your Honor. I just sold my house. I'm set to close on my house the first week of April.
And then where?
Everything's been.
And then where? Then where are you gonna go?
I'm actually gonna buy a trailer and
Where?
here. Somewhere. I don't exactly know yet.
Anything else, Ms. Wiles?
I will say he is compliant with all the other aspects, Judge. He has all his programs completed with the exception of treatment, which he is continuing in. I've updated report from March. He's testing under orange monthly at DNA. It is negative. He was out of town approved for a little while. His daughter was very ill. So he did have a small hiatus, but he kept in great communication, Your Honor. He is very compliant with other aspects.
He's scheduled to come off probation. It would be in February the 7th of 27, right?
That is what I have, Judge.
Anything else?
No, Your Honor. Just that, I'm sorry that this happened and I definitely feel like it's needed.
Well, at least you're respectful. I'm not impressed with your record. some of it dates back a long time. And at least you're acknowledging you did something wrong. That means a lot to me. You're gonna pay costs of $50. I'm gonna order 2 days on the court work program, and you're gonna pay $35 a day for that, for a total of 70, for a total of 120. I'm gonna let you pay your fines and costs at the rate of 50 per week, beginning April 10th. I want you to remember what I said to you. If you don't have the money, it's not the end of the world, but you gotta communicate with us, okay? You gotta come and talk to me, or you can call in, go on Zoom. I'll be glad to give you an extension. I don't care how many times we have to do that, all right?
Yes, sir.
Okay, so she'll set you up. I wish you well. Hey, listen, no more contact with courts, okay?
Yes, sir.
All right, good luck.
Thank you, Your Honor.
All right, thank you. Do I have anything else down there, guys?
No, we just wait on that, Terry's.
What about the one with the sentencing? What time is that scheduled?
Well,
1 o'clock.
Okay,
this would be some really,
all right. What is your name, sir?
it's Mr. Man, he's 9:30.
Is that a civil? Who's
It's
the
a
plaintiff?
small claims.
He's the plaintiff, small claims.
Oh, okay, so we don't have the,
Do you have Thompson's appliance out there, Jim?
No, they're not on Zoom.
Okay.
Nor the small claims are told to come in person.
Okay.
Deontay Coleman is not here, right, Jennifer?
Correct, Your Honor. He's not on Zoom, and I believe he's not in the courtroom either.
All right, I'm gonna ask you to raise your right hand. You solemnly swear to affirm under penalties of perjury, the testimony you'll give in these proceedings will be the whole true self you got.
Yes, ma'am.
Okay, so you have here a claim that indicates that the defendant owes 1167.17, correct?
Yes,
Is that still the principal sum before we get to everything else?
yes.
And you have what kind of costs here?
The costing was $50 for the filing fee,
Okay,
and then 51 for the original service. And then we did have to file for an alternate service, so there's $55 total for that.
so you've got, correct me if I'm wrong, 50 plus 51 plus 55, right?
Yes,
So that's 156. And you're gonna add that to the, so it should be, correct me if I'm wrong, $1,323.17.
yes, sir.
All right. Judgment for plaintiff. I gave defendant time to appear. This was scheduled this morning for 9:30. Defendant was given 15 minutes. It is now 9:50. I'm signing the judgment. We will send this one down and you are all set. Do you have any others in front of me?
I'm sorry, what was
You
that?
don't have anything else in front of me, right?
No, next day, I'll be back Monday though.
Well, good to see you. I haven't seen you. You've been sending in all the, is it you sending in all the consents all the time?
Yeah, probably. On one of the last ones I had, it was probably at least 10 cases, and I think I only had to come in for 2 of them.
Okay.
I consent, so it was really good.
Well, that's good. Thank you.
I did have, already filled out a pre-check, like a judge that already filled out.
See, you're too good, but I filled one out anyway.
I see you already. So it's okay.
You're all set. Thank you. Bye now. Edward Mann versus Thompson's Appliance, 2600096. Gosh, I hate these. Your name?
Edward Mann,
You paid them and they didn't show up.
I gave him a $200 deposit and he never returned the report.
Look, I wish I could give you, I see you're asking for to be paid for the amount of time that you waited at your wage rate of what, $47.25. I just can't do that. I wish I could, but I can't. So I'm gonna enter I just don't understand some of these people. I mean, how corrupt is that to take money and not show up? I'm going to give you your judgment. I want to make sure I include everything that is out of pocket. You had a $42 filing fee, right?
Yes.
What about a service fee?
Your Honor, he had a $42 filing fee, a $20 motion fee because he had to do alternate service.
Right.
And then $69.25. So in service fee, so $131.25 is what I'm showing.
And then there was another $20 for a second mailing that I paid last time I was in the court.
How much are you coming up with?
I've got $331.25, not including any of the hours of my time and that kind of thing.
Yeah. Yeah, I just can't do that. I'm sorry. I'll give you your judgment. It'll be for 331.25 for the record. Case was scheduled for 9:30. I gave the defendant 15 minutes. It's now 9:53. So if you go down the hall, he'll bring the file down. They'll give you a copy of the judgment before you leave. Okay?
All right, thank you.
Have a great day.
Thank you.
Good luck on collecting that.
Well, I was gonna ask.
Well, you send that to them, and if they don't pay you within 21 days, I would set up a creditor's exam. And that's a subpoena where you can tell them they have to bring all their bank records. There's forms you can go online and look at. Like, just think if you were trying to collect from me, right? You'd ask me to bring my W-2s, my tax returns, my bank account statements, my stocks, my bonds, whatever it is that I have, and then you can examine, then you can start garnishing.
Okay,
Okay?
yes, am I able to assistance and report on that if,
We can't give legal advice, but they,
just would go to.
yeah, we can give you the subpoena for a creditor's exam.
Okay.
And you can actually take one of those forms now and look at it and hope that he pays within 21 days. If he doesn't, then you can go after him. And that, that's where I would start anyway.
All right.
Okay?
Thank you.
Best of luck, Mr. Mann.
Thank you.
Cavalry SPV 1 versus as assignee of Citibank versus Sabrina N. Paul, 2600394. Good morning.
Good morning, Your Honor. Angelina Abu Farha, P number 88197 on behalf of plaintiff.
Good morning, Miss Paul, your name?
Sabrina Paul.
Did you two talk and try to work something out here, counsel?
Yes, we did, and defendant did offer a settlement. I do believe my client will accept. I do have to go through the procedure of submitting it to my client, but I have high hopes that they'll accept and this
You
will be
need to
settled.
do that.
I'm sorry, Your Honor.
I'm going to give you an adjournment. I'm just asking how long it will take for you to get a hold of your client.
Not that long. They respond fairly fast, so if you want to adjourn for 30 days, that'd be good.
All right, give me a date 4 weeks from today, that week that I'm here, if you
April
would, please.
27th.
April 27th, we can make it at 8:30, Jen?
Yes, Judge.
April 27th at 8:30. And we'll go from there, okay, Ms. Paul? You don't have any objection to that, right?
No, that's fine.
So I'll adjourn that pretrial again to April the 27th. And that will be at 8:30 in the morning. And hopefully you guys will resolve it. If you have the dismissal order in hand before that, because it's been resolved, then you don't have to show up on the 27th. But if you don't have a dismissal order, I would still appear by Zoom on that date and at that time. Okay, ma'am?
Okay.
All right. Anything else, Ms. Abafar?
No, Your Honor. Thank you.
Have a great day. Thank you.
You as well. Thank you.
Thanks. All right.
We have an in custody downtown. I called him, just waiting for Zoom.
Okay. Is Mr.
Shut.
Okay.
What's your name? Tom Vasquez.
Is that a phony or?
Yep. Said being on record, Morrison did the other day. CSC.
Oh.
I called him one time.
See. So you guys see who she's.
Yes.
Infinity food. Everybody is.
He said 30.
And I sat there, but I couldn't figure out.
Oh, like their organization.
Yeah.
where Stuff goes.
Yeah.
And I'm very particular about stuff like that, so it's something I'll definitely have to.
Right.
Thank you.
Did you hear from them yet?
He said 30 seconds. 30 seconds.
All right, why don't you call in Mr. Shemke?
You have to send text to.
Do I have?
Here we go.
Christopher Scott Cowgar, 26B704030. Would you text Mr. Shemke?
Yeah.
One second, sir. We're waiting for your lawyer to walk in. All right, again, Christopher Scott Cowgar, 26B704030. Your name, Mr. Shemke?
Maybe have my client's trying to set to mandate her via Zoom as the arraignment to a formal reading by client's interview.
Sir, your name?
Christopher Connor.
Detective, your name?
Detective Sergeant Morrison, Brownstown Township Police Department.
All right, so we have here, sir, give me 1 second, please. Yeah, I signed the complaint in the back. Was in the front, but at any rate, you have 4 counts of CFC 2. You have 1 count of CSC 4. You have the right to remain silent. You do not have to say anything. If you say something in or out of court, whether orally or in writing, it can be used against you. Do you understand that?
Yes, Your Honor.
You have the right to be represented by your lawyer not only today, but at all subsequent court proceedings. If you ever choose to submit the questioning with law enforcement officials, you have the right to be represented by a lawyer at that questioning as well. Do you understand that?
Yes, Your Honor.
You have the right to a probable cause conference within 14 days. You're going to be in front of Judge Hessen on that. The probable cause conference will take place on April the 7th. And that will be at 9:15 in the morning. You're going to be in front of Judge Hessen on that. At that time, your lawyer will discuss this case with the prosecutor. At the preliminary exam, that will take place on April the 14th, and that will be at 11:15. At the preliminary examination, as to each one of these counts, sir, they have to prove that the crimes were committed and that you were the one who probably committed the crimes. If they prove that, you will be bound over for further proceedings to the Wayne County Circuit Court as to any count that they prove that as to. If they fail to prove probable cause as to all counts, then they'll all be dismissed and you will be discharged. Do you understand that?
Yes, Your Honor.
So again, I'm going to repeat, probable cause conference will be on April the 7th at 9:15. Preliminary exam will be April the 14th at 11:15. Do you intend to hire? talk to me, Mr. Cowgar. Are you,
Yes,
are you?
I was asking the sergeant if you could write down those dates and times for me. Gotcha.
We'll get them to you. And also I want to make sure that you understand that, you have the right to fill out a petition for a court-appointed lawyer. Do you intend to hire your own lawyer, or are you going to file a petition for a court-appointed?
At this time, I'll do a coin appointed.
Okay, so he'll make sure that you fill out a petition before you leave. All right, let's address bond. What would you like to say?
Your Honor, my client's 47 years old, currently lives in Brownstown with his wife and kids. He does work at Princeton. He's a structural builder. I know that he recently he purchased some properties. Financially, he'll have a difficult amount with a high monetary. I'd ask for consideration for reduction of bond, at least a 10% or cash surety division. Thank you, Judge.
How long have you lived at 18411 Pine West?
7 years, Your Honor.
I'm sorry, how many years?
6 or 7 years, Your Honor.
All right. Detective, what would you like to say on this?
Your Honor, I would ask the court to consider a cash bond. Also, no ability to leave the state unless first seeking permission from the court, and also no contact with any minors under the age of 18.
All right, sir, I'm going to tell you your bond conditions first. You cannot leave the state.
A normal drive home turned into a nightmare when 6 gunshots were fired on a busy Texas highway. Now, months later, a jury sat quietly inside a courtroom as prosecutors prepared to explain why they believed the man sitting at the defense table was responsible for a shooting that nearly became a murder case. The trial began with the defendant standing before the jury as the indictment was read aloud. Prosecutors accused him of aggravated assault with a deadly weapon, alleging that while driving on a public roadway, he knowingly fired a handgun into another moving vehicle. According to the indictment, one of those bullets struck the victim, causing serious bodily injury. When the judge asked how he pleaded, the defendant answered with 2 simple words: not guilty. With that, the trial officially began, and 12 jurors prepared to hear 2 completely different versions of what happened that day. The prosecutor's opening statement immediately captured the courtroom's attention. He told the jury that this case was about a miracle. According to the state, the victim Hunter Freeman should not have survived. Prosecutors claimed that during a road rage confrontation, a bullet entered the victim's face near his mouth, traveled through his cheek, and exited just below his ear, missing vital organs by only inches. They described his survival as nothing short of miraculous. But the prosecutor said there was another hero in the story as well. A passing driver witnessed the aftermath, stopped to help the wounded victim, called 911, comforted him while he bled on the roadside, and even contacted his mother before emergency crews arrived. Prosecutors called this stranger the angel in the case, someone whose action... Imagine standing before a judge, knowing that one guilty plea could change the rest of your life forever. That was the reality for this defendant, who appeared in court charged with breaking and entering a building, a felony offense carrying serious consequences. But before accepting the plea, the judge refused to rush the process. She carefully explained every constitutional right the defendant was about to give up: the right to a trial, the right to confront witnesses, and the right to force the prosecution to prove the case beyond a reasonable doubt. The defendant confirmed that she understood everything and admitted she was pleading guilty because she had actually committed the crime. It was a calm courtroom, but everyone knew this decision would shape her future. What made the hearing especially interesting was that the plea agreement didn't include any sentencing recommendation. The prosecutor agreed to dismiss another charge of assault and battery, but the judge still had complete authority to decide what punishment would eventually be imposed. Instead of sentencing her immediately, the court ordered a pre-sentence investigation. That meant probation officers would interview the defendant, review her criminal history, employment, family background, and personal circumstances before giving the judge a recommendation. It was the court's way of making sure the sentence fit not only the crime, but also the individual standing before the bench. The judge reminded everyone that accepting a guilty plea doesn't automatically mean someone goes to prison the same day. Sometimes the court needs more information before making a life-changing decision.